tardes.
Good afternoon and welcome back. We're gonna get started with the round table. And what's better for this time of the day to talk about legal aspects? This is the legal round table. We want to keep you awake. Okay, so going back to the agenda. So going back to the agenda today. Maybe I need to introduce myself. My name is Campione. You saw me yesterday. I'm a member of the SIBI Scientific Committee, and I had the honor to take part in organizing this conference. And my name is Vitulia Álvarez. I am the director for the genetics laboratory of the General Hospital as a study, basically head of the basic clinical research group in neurology at ISPA. I also was the director of the ISPA last year until January. It is an honor for me to be here today. Isolina invited me as a genetist. I was paying attention to this since the year 2000, this map of the genetic edition, the genetic map, and I am interested in knowing more about the legal aspects, which will be the big because in that case the doubts that we at the hospitals have can have something to get a hold on to. We can know more about the main purpose of this, which is preventing diseases or curing diseases. So first of all we have the intervention by Dr. Ivonne, who's a professor of private law at the School of Law of the Salerno University in Italy, professor of civil law at the Specialization School for Legal Professors, a member of the Scientific Committee of the SIBI, president of the Scientific Committee of the Medical School in Salerno, was the co-director of the International Summer School about Law, Bioethics and Health, University of Salerno. She is a main principal investigator in national and international research projects and reproductive rights, as a member of the Italian and German Vitulia research group about legal and ethical aspects and decision making of life in Germany and Italy, and a member of the research group on bioethics and international law in the relationship between life, death and human dignity. She focuses on bioethical and biolegal topics related to the right to health and the beginning and end of life, informed consent, medically assisted procreation, genetic tests for pre-implantation, etc. But she also takes an interest in gender, intellectual property, scientific research freedom, protection of cultural goods and biotechnologies. Professor Ivonne Sarvigan couldn't make it here, but she has sent her speech, so I have to read it out. And I'll try to imitate her voice, but since I don't know her personally, you have to settle for my voice. I'm I'm not gonna read it because, of course, it makes no sense for me to read it in Italian, so I'm gonna translate it. So please bear with me. But because I'm the moderator, I need to moderate myself, so I need to let me know when I only have 2 minutes left. I have 20 minutes, right? 20 minutes. So this is the speech by Dr. Ivonne, Advanced Therapies and Intellectual Property, European Standards in Italy's position, which is always interesting. The subject of advanced therapies crosses the field of intellectual property when they perform the function of representing a curative breakthrough for patients and for the National Health Service, especially since the subject of pharmaceutical innovation requires an integrated reflection, which must be carried out with due attention. This assumption implies a reflection on the scope and operability of the intellectual property system applied to the pharmaceutical field, which has always been an eternally moving and ever-changing sector. It must be considered that therapeutic innovations, especially when assisted by new technological tools, require the attention that is reserved for those fields of science that are constantly revising their legal categories of reference. The great global debate on advanced therapies focuses on development, investment, and accessibility of individual patients. But the consequence is that there cannot be an overlapping between therapies, even if they are aimed at treating the same pathologies. For this reason, the identification of the specific subcategories of patients for whom treatments may be appropriate often takes place thanks to companion diagnostics. I was given a text translated by Deeple, and the translation was wrong, to no one's surprise, which helped. Of course, artificial intelligence is far from useful in this case. So, as I was saying, they help to provide the recipients of treatment, thus making each treatment de facto unique and infungible, with consequent repercussions on the very definition of the treatment on the target markets. Between the end of the 19th century and the beginning of the 20th century, the pharmaceutical sector underwent a radical transformation, marked by the industrialization process of the drug. The advent of the Constitutional Charter, which defined health as a fundamental right of the individual, made it possible to guarantee generalized pharmaceutical assistance. And then, with the advent of the Italian National Health Service, developed a universalist and egalitarian model that gives every citizen the expectation of care that conforms to uniform standards of levels throughout the national territory, as established by Law Number 833 of 1978. The National Health Service is a system of structures and services whose purpose is to guarantee universal access to the equitable provision of health services to all citizens, implementing Article 32 of the Constitution. The fundamental principles of which the NHS has been based since its establishment are universality, equality and equity. These fundamental principles are complemented by organizational principles that are basic to healthcare planning. The most important are the centrality of the person, public responsibility for the protection of the right to health, collaboration between the levels of government of the National Health Service, and social and health integration. Thanks to technological and scientific progress, the advent of industrialized medicines has favored generalized access to care, ensuring the large-scale availability of therapies for widespread pathologies. As I was saying, widespread pathologies. In Italy, the industrialization of the sector has therefore proved synergetic with the objective of guaranteeing generalized pharmaceutical assistance as a central component of the fundamental right to health. What did that do? That has made possible the manufacturing of cereal products, and consequently the overcoming of the previous vision of the the medicine as a craft product conceived thanks to individual expertise and set up on the basis of relational continuity between the doctor, the pharmacist and the patient. In particular, industrial manufacture constituted the culmination of an evolution that, from the initial galenic formulations, led to the standardized production of identical medicinal products intended to satisfy a homogeneous need specific to a large population of average patients. Such an incisive transformation has also prompted the gradual definition of a regulatory governance of the sector, which has necessarily taken the type of drug products as a reference. So the regulations have given rise to functional fulfillments aimed at guaranteeing the safety and efficacy of the drug on the assumption of a compulsory contextualization of the risk-benefit ratio, which varies according to the severity of the pathologies treated in application of the principle of primo non nocere or nocere. The concept of advanced therapies, the advanced therapy medical products, medicines for human use that are based on genes or cells offer new treatment opportunities, especially for serious untreated or chronic diseases, for which the conventional approaches have proved inadequate. There are four main groups: gene therapy medicinal products, somatic cell therapy medicinal products, tissue engineering medicinal products, and a combination of advanced therapy medicinal products. In terms of regulatory sources, the EC Regulation 1394/2007 is certainly the regulatory framework of reference for ATMPs, amending Directive 2001/83 and the Regulation 726 of 2004, laying down community procedures for the authorization and supervision of medicinal products for human and veterinary use.
and establishing the European Medicine Agency. In addition, Directive 2009/120 updated the definitions and scientific and technical requirements for gene therapy and somatic cell therapy medicinal products. It also established detailed scientific and technical requirements for tissue-engineered medicinal products, as well as for ATMPs containing medical devices. As with any medicinal product, the development of ATMPs must also comply with Directive 2001/20 related to the implementation of good clinical practice and the conduct of clinical trials on medicinal products for human use, which also lays down specific rules for this type of products. Because of their complexity, the EMA has provided new clarifications on the evaluation procedures for advanced therapy medicinal products with the aim of simplifying certain procedural aspects. Strengthening collaboration between the EMA scientific committees and supporting the developers of these medicines, which are often small and medium enterprises or academic spin-offs in the regulatory process of the first market authorization. More specifically, advanced therapies are gene therapy, cell therapy, and tissue therapy. These are innovative biological medicines that contain genetic material or stem cells that have undergone a biological process carried out in highly specialized laboratories. Advanced therapy products hold promise for the treatment of chronic and serious diseases. ATMPs are evaluated by at least three EMA scientific committees: the CAT Committee for Advanced Therapies, the CHMP Committee for Medicinal Products for Human Use, and the PRAC Pharmacovigilance Risk Assessment Committee. The update aims to make interactions between authorization applicants and the EMA more timely and effective. Its principles also apply to post-authorization procedures. The work of these committees, with the active participation of the European Commission, led to the creation of a document that is the result of the joint action plan published by the European Commission and the EMA, with the aim of streamlining procedures and better addressing the specific requests made by bodies and laboratories involved in the development of innovative biological medicines. The complexity of ATMPs requires specific expertise, and the evaluation criteria sometimes go beyond those applied to the traditional pharmaceutical sector, taking into account the rapid development of scientific knowledge. For these reasons, the AMA, or the Committee for Advanced Therapies, was established within the EMA in accordance with Regulation 1394/2007. The main responsibility of this committee is to prepare an opinion, a draft opinion, drafted by 2 member states on each application for marketing authorization of ATMP, to be submitted to the CHMP for the adoption of the final opinion of the medicinal product concerned. So it is possible to access advanced therapy medicinal products not yet authorized or not subject to specific clinical trials in Italy, subject to the authorization by the ISPA for production and use. In the absence of a valid therapeutic alternative in cases of urgency and emergency that place the patient's life in danger or serious health damage. In the Italian legal system, the pharmaceutical product must conform to certain production processes and controls which are recognized and codified on the basis of specific technical regulations in the sector, so that the product's margins of variability are minimized and do not determine a risk factor in their own right. Therefore, they contribute to altering the safety-efficacy ratio of the treatment. Article 2 of Directive 2001/83 expressly limits its scope to medicinal products for human use that are industrially manufactured and intended to be placed on the market in the member states. Only to these, thus, the pervasive discipline envisaged by the legislature apply for all phases of the life of the medicinal product, ranging from research and development to production, promotion and marketing, to post-marketing supervision. If the rules on medicines were thought of on the assumption of an industrial production model, it is difficult to translate them to the various categories of advanced therapies, which appear to share a factor that distinguishes them from traditional product drugs. With respect to the latter, in fact, the new solutions are characterized by the atypical nature of the preparation, which is intended for a limited number of patients with an activity more similar to a craft rather than an industrialized one. It is necessary to assess what regulatory discipline is applicable to individual preparations that are outside the industrial scheme, because they are made in a non-repetitive manner for individual patients, without, however, being assimilable to galenic formulations, because they differ in the level of technology required. From the point of view of the rules, the community legislature intervened with Article 28, Regulation 1394, that exempts from the regulatory discipline laid down by the regulation I'm gonna try and speak faster. I need to do some CRISPR technique on this speech. Okay, let me finish this paragraph and then I will move on to the conclusions. So let me find the paragraph. Okay, let's move on to the conclusions. Well, I just want to really summarize this. I cannot talk about patentability of all these, because with advanced therapies, the patent issue takes on further centrality since the opening up of new clinical frontiers related to the manipulation of the living brings with it, in addition to incredible prospects for cures, also some relevant questions related to the interpretation of on the subject. In Europe, the original patent system has been updated. And now I will move on to the conclusions, because advanced therapies are outlining a model of treatment that is totally alternative to those that have been traditionally characterized in the pharmaceutical sector. They have rendering obsolete most of the assertions on which the framework of regulation concerning authorization, patents, and drug prices, as well as the consolidated vision of public-private partnership, has gradually been founded. Beyond the diatribes attributing stereotyped positions to the pharmaceutical industry and the public sector, it is therefore necessary to identify that communion of interests, which also in legal terms can facilitate innovation and virtuous partnerships, including in relation to the way in which expenditure on advanced therapies is financed. Thank you.
Para la doctora Ivonne. Y sin solución de continuidad, pasamos a...
Now we move on to the second speech by Dr. Pilar Nicolás Jiménez, who will be talking from the lantern. Dr. Nicolás is a principal investigator of the Basque University System Research Group on social sciences and legal sciences for new technosciences, coordinator of the Law and Human Genome Chair, a member of ANSEI, the National Association of Ethics in Investigation Committees. She's also a member of the LC Group, Ethical, Legal and Social Issues, and the 1 Million Genomes Initiative of the European Commission, the Commission on Ethics and Scientific Integrity of the Impact Program, the Regulatory and Ethics Group of the Global Alliance for Genomics and Health, the Renacer Scientific Committee, the Planning and Management Committee for Personalized Medicine in the Basque Country, and Genome Galicia. She's a coordinator of the ELSI in Spain, of the BBMRI ERIC, has participated as a principal investigator or a member of the team in many projects on biomedical law, for example, UCAN and UCAN Image. She has also collaborated in drafting Spanish legislation on biomedical research, and she will be talking about interventions on the human genome, requirements for the approval of research on clinical application of the technique.
Thank you so much for the kind invitation, and thank you to the SIBI for having invited me, especially Marcelo Palacios, Isolina Riaño. Thank you so much. It is an honor to be here with you and share this program with such international experts and national experts. My master, Carlos Romero, for example, I love to share agendas and to attend such an international conference with great personalities. I have been asked to talk about prerequisites to approve of interventions in human genome research and clinical application. What do we have to do to intervene in HG legally? So I have to divide my presentation in 4 stages. First of all, what do we refer to with the term interventions in GH, or HG in English, human genome? What does the legislation understand? How to address the practice from a legal standpoint? What do we place it systematically? What are the principles that are applied? What is the general standpoint of this technique to later on go to procedures? And to specify some pathways of control, authorizations, etc., etc. That is the last step of my talk, and then some conclusions. When we talk about interventions in human genome from a legislative standpoint, we are referring to something that is so broad, so large. For example, genomic editing of embryos that resulted into the birth of the twin girls. You all know about this experiment.
En el año 2019 como reacción, ¿no? Ya saben todos que el propósito era una manipulación para evitar.
So you know this was a manipulation to avoid also a disease, and it affected a germline. But we also talk about a therapy, a somatic therapy to treat a disease, for example, the sickle cell disease. And it is cured, or it is possible to cure it with a therapy that affects the somatic line. So, from the technological standpoint, these therapies may use different tools. The legal standpoint is very different. Although, when we are addressing HG intervention, we are talking about the modification of a genetic sequencing of a being through techniques of molecular biology acting on the DNA molecule. The aim will also mark regulation and requisites. We can determine that the aim is a therapy or a prevention or improvement of capacities, aesthetic or well-being improvement, something that does not relate to cure. Or even it can have another target in terms of design. Not everything is feasible. Sometimes we think that we're talking about science fiction, but the ethical evaluation may be different. When we talk about design, for example, we refer to the fact that in this manipulation we are including features of other species or sequences that are not present in other being. We can talk about genome intervention, but maybe the result already exists in another living being or living creature. But the possibilities are not only those ones, there are many other. It is also very different depending on the scope, individual scope or collective scope. Because we're talking about inheritance, and collective may be very few subjects, just some relatives within the family, or maybe we're talking about a greater scope. And well, it is true that this kind of evolution or difference exists in nature, It has always existed, but now we are thinking about the impact if it is a human who, with a technique, the one that is intervening, and whether the new techniques mean not only a quantitative leap, it is faster, it is cheaper, it is more accurate, but also a qualitative leap, and it deserves another evaluation. Taking this uncertain scenario with a very different technique, with very different implications depending on the level of action, it is addressed by the regulatory framework, and different rights, interests and legal goods are identified. First of all, to protect the individual's health. First, we talk about the right to protection of health. So the individual has the right to receive from the state some delivery, some health delivery. It depends on the political decision, but when it is made, it has to be made based on equity criteria and fairness criteria. And this will be very important when implementing the therapies. There is another dimension, that is the right that the physical integrity is not affected by risks. So experimentation only poses minimum risks. The therapy should pose risks that can be assumed, and they are included in a trial or a procedure that has been validated. There are other aspects to be taken into account. Reproductive freedom. People have a right to take decisions in terms of their reproduction, whether they want to have kids or not, how many, but what else comes into this reproductive freedom? Maybe there is a right to decide not to continue with pregnancy when there is a certain pathology. There is the right, acknowledged right to selection of embryos due to therapeutic reasons, and withdraw those that have a pathology, and that exists as part of the reproductive freedom. How far goes this freedom? Genetic integrity is also being protected, and I mean that it is a genetic heritage that is going to be received, that has not been altered or altered at random. And we have an individual integrity, but also collective dimension, because that heritage belongs to human species. We also have the research freedom, which is a fundamental right of scientists, but it also provides a social benefit, generation of knowledge, wealth, future therapies, etc., etc. So it is a right, a fundamental right, that has to be limited only if justified. And finally, market freedom. Companies have a right, if we can may call it so, to develop business activity and obtain profit. Of course, with some criteria, but the right is there. On the basis of these principles, I will not go into detail here. Tables always simplify too much things, but it's just to give you a mere idea. the criteria or the profile or the items are taken into account to prohibit some practices. With these practices, genetic modification will not be discussed because they are prohibited and they cannot be authorized. So we're going to withdraw it. What you have in red there, the different rows of the table refer to norms of different nature and promoted by some other institution, and in the columns we have prohibitions and techniques that are permitted with some limitations. Is there a unanimity to prohibit those therapies that do not have a therapeutic aim? There is no unanimity in relation with the fact that whether the manipulation is performed with a germline or a somatic one. So we find, for example, Spanish legislation that allows for genetic manipulation, even in germline, if the aim is therapeutical. It is not prohibited by the assisted reproduction law. The germline manipulation if it is therapeutic. The same goes for the criminal code. The genotype alteration is not allowed if it is not therapeutic. So there are issues that are prohibited, some issues that according to the norm they are not fully prohibited, and we will have to think about the routes or the pathways to turn them into legal. There are some prerequisites you have to follow. I will try to speed up, but if you have any question, we can ask me later on. Let's go to the prerequisites. There is no way but to distinguish different scenarios, because as I have said from the very beginning of my talk, we are referring to very different techniques with different impacts or implications. This is what the WHO has understood when analyzing the level of governance, that is procedures, implementation, requisites to authorize these techniques. And the criteria of the WHO is the following. What you have to do is to differentiate the different scenarios. I'm going to propose the following routes and the most realistic ones. Firstly, experimental genetic editing in gametes and pre-embryos, not targeting reproduction. And this is germ-line editing. We are manipulating gametes or pre-embryos, and that manipulation affects heritable line. It is germ-line editing. But one thing is germline editing, and another thing is to affect our inheritors. If we talk about this kind of editing of some entities that will not aim to reproduction, they will not be inheritors. there will not be any reproduction, that will not be replicated. Article 13, Convention of Oviedo, prohibits genetic editing in germline and highlights that this prohibition does not include experimentation in eggs and spermatozoids. It is true that pre-embryos are not here included, but I think that the Convention of Oviedo in the matter of pre-embryos is very cautious. In fact, when they talk about experimentation with embryos, say in the countries where experimentation is allowed. So although the explanatory report does not say that pre-embryos are not excluded, we have to understand that they are excluded, if not aiming to reproduction. This practice is not included in the criminal code of Spain. It prohibits germ editing to eliminate or to eradicate diseases, but the criminal code, Spanish criminal code, as Carlos Romeo has already mentioned in the protection, includes also intrauterine life. Maybe other legislation protects entities before pregnancy. A criminal code, this is where things start, when protection starts. So we're talking here about intrauterine life, but not before. So these entities are not protected. It is not included or protected by the law on assisted reproduction, because there has not been any reproduction, and there is a limitation to experimentation that implies genetic manipulation between embryos, pre-embryos and gametes. There is one clear statement regarding the production of interspecific hybrids. I have 2 minutes left. Okay, I feel very bad because this is only the first stage of the first pathway of control. So I'm not doing very well. Okay, so maybe we may say that experimentation that aims at genetic modification between gametes and pre-embryos, germline, not aiming to reproduction. I think the national regulatory framework does not prohibit it. Of course, it should follow or satisfy some criteria. I will not go into detail because I only have 1 minute left now. Next scenario is that of genetic editing in pre-embryos for implanting. Again, if we talk about genetic editing in pre-embryos, we're talking about genetic editing in germline. And therefore, the therapeutic, non-therapeutic line is not included. If it does not have a therapeutic aim, and if it is included by the criminal code, Spanish criminal code. But here we have an intrauterine life when implanted, so we understand it should be part of this crime included in the criminal Spanish code. There is an alteration of the genotype. So in this regard, we have a strict requisite. So the aim has to be therapeutic. And this is the prior prerequisite to be implanted. As for genic therapy in embryos and fetus, fetuses, legislation authorizes therapeutic interventions in these entities. Embryos and fetuses should be handled as patients. You have to authorize the treatment, prevent risks, informed consent, etc., etc. We're going to talk now about research in vitro cells and tissues. We're not talking anymore about affecting or handling a pre-embryo. We're talking about a body, or a part of a body, rather. The aim should be basic research. We will apply the well-defined pathways according to legislation for sampling, etc., etc. It is an in vitro research, basic research, and the aim is to produce interspecific hybrids again. And finally, clinical trials. And I related to the previous speaker's talk. Clinical trials with genic therapy are allowed. As long as it is germ-line. They are considered as drugs of advanced therapy. And legislation on clinical trials is followed with some specificities. For example, for the ethic evaluation, you need experts in ethics. The SEIM, the committee, should have this counseling. And then we have marketing and authorization, another stage, because they are manufacturing industrially these items, so you need an authorization case by case with a specific norm for this kind of therapy. And it is important the possibility of non-industrial manufacturing process. So for example, manufacturing for just one individual who needs it and is in hospital. And that is where the manufacturing ends. I will finish with my last stage. Control routes have been followed, the trial has been performed, the drug is working, functioning, and now you have to negotiate to introduce the drug in the national system. First, you need to evaluate. It is a kind of a report to assess the implant in the system. In this regard, in January next year, a new norm will come into force, which will urge more coordinated processes between all the European countries. They are not binding, but they will be very relevant for the states, because there will be a report by a coordinating committee that will have more into account the specific issues related to advanced therapies, and then you have to introduce the drug in the health system and negotiate the price, and this is a hot potato as well, and then you have to administer it following Law 41. Conclusions. We cannot talk about a roadmap for authorization, but rather many practices, many pathways with lots of boundaries. Some boundaries are very clear, and others not so clear. The designed borders are boundaries are much more clear, but it is not so clear to say or to define what is a disease, what is not a disease, what is well-being. That is not so clear. maybe you should have a restrictive criteria, thinking about safety, authorization, case by case maybe. Safety is key, consent, supervision, follow-up, etc. Well, in all my slides, I always named the authorization by ethic committees, etc. So ethic committees look into social issues, ethical issues. Should also be valued here. And we also have to evaluate the benefits and who is going to benefit from this therapy. Will they be on an equity basis, everybody benefiting from them or not? Or maybe it's only going to benefit few people. We need to apply equity and fairness criteria. I'm sorry for taking so long. Thank you.
Muchas gracias. No, vamos a terminar el turno de ponencia.
We're going to finish with the next presentation. You can sit here at the panel. Well, you can sit wherever you wish. Well, all of a sudden, the chairman orders my genotype is overvalued, I tell you. Now we'll move on to the next presentation by Laurence Assou-Bazé. She is a lawyer, she is a mediator, she is a doctor of bioethics, co-chairwoman of the School of Lawyers in France, Delegate of Health of the Association of European Mediators, National Tutor of Health 2017. She's member of the Institute of Training in Human Rights of the School of Lawyers in Paris, member of the Institute of Human Laws European Lawyers (ISPA), member of the French Association of Chairs or PhDs in Law, former president of the Association Accord ad hoc International Mediation, member of the Council of Administration of HUCA France, vice president since 1st of January 2023 of SIBI. And then she has also worked for the Scientific Council of the International Society of Bioethics in Gijón, 2001-2002. She has been professor, many publications, books, too long if I had to name them all. And here with us at the panel, our great president, Isolina Riaño, who is also a French translator today. Thank you very much. You have the floor. So she's going to talk in French. Yes. The simultaneous interpreters from the booth will translate in English. Laurence is going to address you in French, and I'm going to make a very brief summary, not literal, just a summary in Spanish. And I will make comments in Italian. There you go. You have it all. Enjoy it.
Thank you very much. I want to talk about, I'd like to thank Marcelo Palacios and Beatriz, who never ceases to work, Isolina, and all the team. And I have to say that this conference is very diverse and very rich. And as you know, it's for we have many advances on CRISPR. As a legal expert, we have to be very modest and humble. I have the honor to present the legal text, and especially I would like to thank Dr. Casabona, who has always helped me, especially because thanks to him I know the Convention of Biomedicine.
agradece al doctor Marcelo Palacios, a Beatriz, a todo el equipo de la SIBI por la organización de todo esto y por estar abierto a los avances científicos. También agradece al doctor Carlos Romeo porque ha participado en toda esta temática y en la regulación de estos temas.
Alors, très rapidement, je voudrais dire que j'ai conçu.
When I want to say that my intervention has three parts. The first one will be about the definition of CRISPR, but since we've been talking about CRISPR definition for a few days already, we can skip that and we can move on to the legal aspect. So, the law applicable to CRISPR, the second point, and especially, well, in the first place, the texts, the legally binding texts.
Sobre la definición de CRISPR, porque ya se ha hablado mucho a lo largo de esta jornada y ayer.
Alors, concernant les instruments internationaux, il faut dire qu'ils
So, the international instruments available in the sphere of bioethics have so far only addressed the question of intervention on genomes in a laconic manner. So, I will be talking on the Convention for the Protection of Human Rights and Dignity of the Human Being with respect to the applications of biology and medicine, the Convention of Oviedo, Convention of Human Rights and Biomedicine. Biomedicine is an important word, and it is a real definition of bioethics. This convention is the only binding text in Europe. It was signed in 1997 and entered into force in 1999, and France ratified it in 2011 and then entered into force in 2012. But neither China or the United States signed this convention, which reduces its scope. And it's a pity. This convention incorporates the principles of the Human Rights Convention.
De derechos humanos y la dignidad del ser humano en relación con la aplicación de la medicina y la biología, conocida como Convención de Derechos Humanos y Biomedicina o Convención de Oviedo, cuyo título revela lo que dice, que fue firmado en Oviedo el 4 de abril del 97 y que es el único texto vinculante. Francia lo ratificó el 13 de diciembre de 2011 y entró en vigor en el 2012. Pero señala que ni China ni Estados Unidos firmaron este convenio, lo cual reduce su alcance. Y va a desarrollar todo eso.
Merci Isolina. Alors je voudrais rappeler
From now on we will be interpreting Isolina's words.
Marcelo Palacios qui nous disait concernant cette convention l'action de l'homme pour son intégrité et pour sa dignité. Voilà des mots forts à rappeler. Et vous étiez donc le rapporteur de la commission de la science et de la technologie et le rapporteur général pour la bioéthique en 1990. Donc je voulais rapporter cette citation.
Señala que el doctor Marcelo Palacios, que fue ponente general del Consejo de Europa sobre bioética, nombrado por la Comisión de Ciencia y Tecnología para todo.
Dr. Marcelo Palacios, Rapporteur of the Commission on Science and Technology and General Rapporteur for Bioethics, said that the action of man, the Oviedo Convention is designed for the action of man, for his integrity and for his dignity.
Celle du professeur Andorno, Roberto Andorno, qui disait: la tâche la plus difficile de la bioéthique en matière de reproduction et de génie génétique est de maîtriser des risques inédits pour l'intégrité et l'identité des générations futures.
Sí, bueno, pues que es importante también tener en cuenta la protección de las generaciones.
We need to take into account the protection of the future generations. The guiding idea of the convention is that the interest of the human being must prevail over the interest of science or society. It sets out a series of principles and prohibitions concerning genetics, medical research, the consent of the person concerned, the right to respect for private life, the right to information, organ transplantation, the organization of public debate. In here, I'd like to talk about Chapter 4 of the Oviedo Convention that deals with human genome. Let's remember the most important article, in my opinion, and I was referring to Professor Casabona, Article 13, the interventions on human genome, an intervention aimed at modifying the human genome can only be undertaken for preventive, diagnostic or therapeutic reasons, and only if it's not intended to introduce a modification into the genome of the offspring. The speaker said it is Article 13, but in reality it is Article 12.
Que cualquier intervención dirigida a modificar el genoma humano solamente puede ser llevado a cabo de forma preventiva, por razones preventivas de diagnóstico o terapéuticas, y solamente si no introduce ninguna modificación en el genoma de la descendencia.
Merci Céline. Seulement la convention.
So the convention was ratified before the advent of new techniques to correct some defects, and in 2021 it tried to clarify that term, and we have called the World Health Organization to clarify that too. So in reality, Article 13 prescribes any form of intervention which could have consequences on phylogenesis. And you have already mentioned that since the birth of 2018 of Lulu and Nana, the two Chinese twins born from embryos in which a gene involved in HIV infection was modified, a red line has been crossed. It is important to remember that the only barrier is Article 13 of the Oviedo Convention.
Convención de Oviedo, y hace referencia también, bueno, pues a lo hecho en que ya se habló de la edición de los embriones hecha en China y que no debería haber sido hecha.
Quant à l'article 14, il a...
As for Article 14, it indicates, but it's not really the same subject, that the use of medically assisted procreation techniques is not permitted to choose does not permit to choose the sex of the unborn child except to avoid a serious hereditary disease linked to sex. So this implies that an investigation could previously have been carried out into the risks of the hereditary disease and therefore into the genome. This is what can lead to temptations or attempts at discrimination based on genetic heritage, which Article 11 clearly intends to abstract, under the terms of which any form of discrimination against a person because of their genetic heritage is prohibited.
En el artículo 14 dice que el uso de las técnicas de reproducción médicamente asistida no permiten elegir el sexo del no nacido, excepto para evitar una enfermedad hereditaria grave ligada al sexo. Esto implica que cualquier investigación realizada para evitar los riesgos de una enfermedad hereditaria y el genoma debe evitar cualquier intento de discriminación basada en la herencia genética. Y en ese sentido el artículo 11 claramente dice: ninguna forma de discriminación contra una persona, o sea, está prohibida toda forma de discriminación contra una persona basada en su herencia genética.
Merci Solina. Le deuxième texte dont je voulais vous parler.
The second text is the Charter of Fundamental Rights of the European Union of the year 2000. The first three articles of which relate to bioethics and human rights. Article 1, human dignity. Article 2, right to life. Article 3, which is really interesting for us, right to personal integrity. Everyone has the right to their physical and mental integrity. End of quote. This article concerns more particularly our subjects in the context of medicine and biology. It must be respected in particular. But we must take into account the free and informed consent of the person concerned according to the terms defined by law, the ban on eugenic practices, particularly those aimed at the selection of people, the prohibition of making the human body and its parts as such a source of profit, and the prohibition of the reproductive cloning of human beings.
No puede ser sentenciado a muerte o ejecutado, y el artículo 3, el derecho a la integridad personal. Cada uno tiene el derecho de respeto a su integridad física y mental. Y dice que este artículo pues es importante en este contexto de la medicina y la biología, especialmente porque pide el consentimiento libre e informado de la persona afectada, según define la ley, la prohibición de prácticas eugenésicas, particularmente aquellas dirigidas a la selección de personas, la prohibición de hacer del cuerpo humano, de sus partes, una fuente de beneficios financieros, y la prohibición de la clonación reproductiva de seres humanos.
Sí, Solina.
Now, I need to remember that all the informed consents have their origins in the Nuremberg Code and the actions that took place during the war. The Nuremberg Code is, in this sense, very important.
Donc, après la Charte des droits fondamentaux,
Well, the second text, we have already seen the legally binding texts, okay? But now I will move on to the texts with strong symbolic value. I will be talking about the texts adopted by UNESCO, the United Nations Educational, Scientific and Cultural Organization. So we have the Universal Declaration of the Human Genome and Human Rights from 1997. The first article says that, and I quote, "The human genome underlies the fundamental unity of all members of the human family, as well as the recognition of their intrinsic dignity and diversity. In a symbolic sense, it is the heritage of humanity." End of quote.
Del Genoma Humano y Derechos Humanos, adoptado el 11 de noviembre de 1997, en su primer artículo, dice que el genoma humano apuntala la unidad fundamental de todos los miembros de la familia humana, así como el reconocimiento de la dignidad intrínseca y de su diversidad. Y en sentido simbólico, esto sería la herencia de la humanidad.
L'article 2, chaque individu a
Article 2 says that, and I quote, "Everyone has a right to respect for their dignity and rights, regardless of their genetic characteristics." End of quote. All the international texts talk about consent and dignity. That dignity makes it imperative not to reduce individuals to their genetic characteristics and to respect their uniqueness and diversity.
Características únicas de cada persona con su diversidad.
Merci, Selena. L'article 3.
Article 3, human genome, and I quote, "The human genome, which by its nature evolves, is subject to mutations. It contains potentialities that are expressed differently according to each individual's natural and social environment, including the individual's state of health, living conditions, nutrition, and education."
3, pues habla de la necesidad de mantener y perpetuar esa humanidad, teniendo en cuenta las generaciones presentes deben luchar para mantener y perpetuar esa humanidad, respetando la dignidad de cada persona humana.
Ensuite, je vais passer à un autre texte de l'UNESCO, donc toujours un texte à forte valeur symbolique.
And now another important text because of its symbolism. It's a text that it's the declaration on the responsibilities of present generations towards future generations.
A las futuras generaciones.
Voilà. Alors, elle date aussi de novembre 97.
Approved in November 1997, I will be talking about 3 articles. First, Article 3 on the maintenance and perpetuation of humanity. Then Article 6 on human genome and biodiversity. And I quote, "The human genome, while respecting the dignity of the human person and human rights, must be protected and biodiversity safeguarded. Scientific and technical progress should not harm the preservation of the human species and other species, not compromising it in any way." End of quote.
Sobre el genoma humano y la biodiversidad, el genoma humano, mientras precisa ese respeto de la dignidad de la persona humana y los derechos humanos, y debe ser protegido y su biodiversidad salvaguardada. El progreso científico y técnico no debe dañar la preservación de la especie humana ni de otras especies, ni comprometerlas en ningún aspecto.
Et l'article 8, c'est le...
Article 8, Common Heritage of Humanity. Present generations should make use of the common heritage of humanity as defined in international law without compromising it irreversibly. End of quote. This is important for the future, the responsibility towards the future generations.
Finalmente, el artículo 8 habla de la herencia común de la humanidad, que las generaciones presentes deben hacer uso de esta herencia común, como se define en las leyes internacionales, sin comprometerlas de forma irreversible.
Merci beaucoup. Ensuite, il y a l'article.
And then we have the International Declaration on Human Genetic Data, which is more recent, dates back from 2003, that together with the Universal Declaration on the Human Genome and Human Rights constitutes the only international reference text in the field of bioethics, because the Oviedo Convention only covers Europe. It sets out beyond nomenclature considerations on human rights, including those of the family and the rights of research, as well as a certain number of unequally useful definitions. And I will talk about Article 7. I'll quote, "Everything should be done to ensure that human genomic data and human proteomic data are not used in a discriminatory manner with the aim or effect of infringing human rights, freedoms, and human dignity of an individual, or for purposes leading to the stigmatization of an individual, a family, a group, or a community." Oviedo was firmer in this respect.
En la Declaración Internacional de los Datos Genéticos Humanos del 16 de octubre del 2003, que fue adoptada unánimemente en la 32 Conferencia General de la UNESCO, pues habla de la necesidad, en su artículo 7 sobre todo quiere resaltar de que debe hacerse todo aquello necesario para asegurar que el genoma humano, los datos y también los datos proteómicos humanos no se usan de una forma discriminatoria con el objetivo de infringir los derechos humanos, las libertades fundamentales o la dignidad humana de un individuo para propósitos que lleven a la estigmatización de ese individuo, de su familia, de un grupo o de una comunidad.
Ensuite, il y a l'article 8, je le dirai pas, mais simplement il rappelle.
And then Article 8 that talks about consent. Then we have the Universal Declaration on Bioethics and Human Rights, adopted on October 2005, that for the first time in the history of bioethics, the member states and with them the international community have committed to respecting and applying the fundamental principle of bioethics. It's a general framework to analyze the legal and ethical aspects and implications of CRISPR in particular, especially Article 2 about the objectives, Article 3 about human dignity and human rights, Article 4 beneficial and harmful effects, Article 5 and autonomy and individual responsibility, Article 6 consent, Article 8 respect for human vulnerability and personal integrity, Article 9 privacy and confidentiality, Article 10 equality, justice and equity, Article 11 non-discrimination and non-stigma, and Article 13 solidarity and cooperation. So everything, a little bit of everything. Especially it's Article 4 about the beneficial effects and the harmful effects. And I quote, "In the application and advancement of scientific knowledge, practice, medical practice and technologies associated with them." End of quote. And Article 11 about non-discrimination and non-stigma, and I quote, "No individual or group should be subjugated in violation of the dignity of human rights and fundamental freedoms to a discrimination or stigmatization for any reason whatsoever." End of quote.
Y Derechos Humanos, adoptada el 19 de octubre de 2005, en la 33 sesión de la Conferencia General de la UNESCO, señala que por primera vez en la historia de la bioética los Estados miembros y con ellos la comunidad internacional se han comprometido a respetar y aplicar los principios fundamentales de la bioética establecidos en un único texto. Esta declaración aporta un marco general para analizar los aspectos legales y éticos y las implicaciones del CRISPR en particular. El artículo 2 sobre objetivos, el 3 sobre dignidad humana y derechos humanos. Especialmente quiere señalar que en el artículo 4 habla de los efectos beneficiosos y los efectos dañinos en la aplicación de los avances del conocimiento científico, la práctica médica y de las tecnologías asociadas con ellos, y bueno, pues que puede ser efectos beneficiosos directos e indirectos también en los participantes de las investigaciones o en otros individuos implicados. Por lo tanto, debe maximizarse los beneficios y evitar los efectos perjudiciales, deben ser llevados al mínimo. El artículo 11 habla de la no discriminación y de la no estigmatización de ningún individuo o ningún grupo. Pues eso sería una violación de los derechos de la dignidad humana y de las libertades fundamentales. Y el artículo 16 ya habla de la protección de las generaciones futuras. El impacto de las ciencias de la vida en las generaciones futuras, incluido en su componente genético, debe ser tenido en consideración.
Maintenant, je vais parler du cadre législatif.
So now we'll talk about the French legislative framework. You know that on a certain, the rather rich arsenal of rules which France has adopted in matters of bioethics, on a certain number of strong ideas rests on a certain number of strong ideas which also inspired the Oviedo Convention. For example, through the 3 laws of 1994, corrected in 2004, 2011, 2016, 2018, by way of ordinances, and in 2021. They talk about the autonomy of the person, the principle of beneficence, non-maleficence, justice, or if one prefers, when the chief formulations overlap, dignity, solidarity and freedom.
Más en materia de bioética a través de 3 leyes de 1994 que han sido corregidas sucesivamente y que se apoyan en ideas, fuertes ideas inspiradas en la Convención de Oviedo, la autonomía de la persona, el principio de beneficencia, no maleficencia, justicia, o dice, si se prefiere, en las formulaciones de dignidad, solidaridad y libertad.
Concernant ces lois, elles prenaient en compte en fait les nouvelles techniques de...
We need to talk about Article 16.4 of the Civil Code that specifies that, and I quote, "No one may harm the integrity of the human species. Any eugenic practice tending to organize the selection of people is prohibited. Without prejudice to research standing for the prevention and treatment of genetic diseases, no transformation can be made to genetic characteristics with the aim of modifying the person's descendants." End of quote. This article is very important.
El artículo 16.4 del Código Civil especifica que ningún daño sobre la integridad de la especie humana, ninguna práctica eugenésica, o sea, cualquier práctica eugenésica que lleva a una selección de las personas está prohibida, sin prejuicio de la investigación que lleve a la prevención y al tratamiento de enfermedades genéticas, siempre que no transformen ni supongan cambios en las características genéticas para modificar a los descendientes.
Merci. En fait, depuis les 30 dernières années,
there have been some adjustments in the last 30 years that have mainly concerned the expansion of cases considered as legitimate for the implementation of artificial fertilization and on the information of the children resulting from it and their origins, and the relaxation of the conditions for biomedical research, particularly on the embryo, in particular by Articles L1121 1 and 1121.2 of the Public Health Code, under which this research is possible in certain conditions. And now we'll be talking about the third chapter, the past, the present, and the future of bioethics. What will be the impact of CRISPR and the new possibilities it offers to gene therapy in the field of human rights?
En el campo de los derechos humanos,
le droit à la santé gagnera-t-il, point d'interrogation, sans que les libertés fassent l'objet d'atteintes ou de restrictions?
Sí, ¿cuál será el derecho?
So will we have the right to have our health improved without hindering the people's rights? And this is based on the influence of fear that has encouraged the thoughts of, for example, the ambiguity of many positions. For example, forced sterilizations in China, etc. So we'll be talking about the eugenetic spectrum and the phylogenetics.
Tiempo bajo la influencia del temor de los excesos eugenésicos que fueron animados por el pensamiento de los herederos de Darwin, especialmente su primo Galton, y la ambigua posición de Alexis Carrel. Vamos a pasar a las... Sí. ¿Quieres? Sí.
La conclusion. Alors, la conclusion, si j'avais une chose à dire, d'abord, c'est le droit. Mais quel droit? Le vrai droit? Quelle sanction? On est vraiment dans le flou au niveau juridique aujourd'hui, et c'est vraiment grave. Je pense qu'il faut qu'il y ait vraiment un nouveau protocole concernant la Convention d'Oviedo. Je voudrais dire également qu'il y a le rôle de l'intelligence artificielle qui n'est pas négligeable, et pourquoi ne pas penser aussi aux problèmes de médiation dans le cadre de ces problèmes génétiques, puisqu'il faut remettre de l'humain dans tout ce qui est technologique. Voilà, si je voudrais quand même vous dire quelque chose, j'ai été très frappée par une innovation très récente de ces problèmes de CRISPR dans l'art, dans le bio-art. Et je vous voilà, on a pu mettre de l'ADN de méduses dans un lapin, et le lapin est devenu fluorescent pour le mettre en exposition donc dans une galerie d'art. Donc jusqu'où on peut aller. Également, on a fait la même chose avec un taureau qu'on a rendu fluorescent. Et c'est l'INRA qui a fait cette expérimentation à la demande de l'armée française. Mais ce taureau fluorescent cette idée de taureau fluorescent a été abandonnée. Donc, c'est pour vous donner quelques exemples, des exemples incroyables aujourd'hui concernant le CRISP. Je vous remercie de votre attention et je vous remercie tous de cette belle réunion et riche réunion. Merci beaucoup.
Bueno.
Okay, she concludes in a very summarized way with the title of the presentation. Genomic editing may be a technological advancement with limited perspectives, but as she said, we have to reflect upon the risks and the disciplines that should be involved in that reflection. Thank you so much, Ms. Olina. Thank you. Okay, we have no time really. We are over time with regard to schedule. So there is only time for one question if the question lasts less than 30 seconds. And time starts now. Thank you. Maria Pilar, thank you so much for interesting talk. A very comprehensive mapping about the law coverage on germline editing. What happens if one day the therapy line is permitted? For example, monogenic and then polygenic, because that is what is coming, no, for the future. We imagine that genetics advances much faster, and we discover that those transformations have a double sense, not only curative but also harmful effect, maybe. What do you think the science can do, no, or the law can do in this regard? Do you think the law could prevent that double potentiality of transformations in germline? And what happens, for example, if we have new forms of improvement or healing? Yes, you have to stop now. The chairman is saying it has been clear, clear the question. Thank you. If I understood well the question, what happens if there are no wished effects, okay? You permit the technique because they consider it is therapeutic, but then as a consequence there are other effects, consequences. Yes, a transformation may be healing per se, but then the same transformation of a gene or polygenic may be something different. Yes, but when you allow for a certain activity, you have to describe and limit the purpose and the aim and what is going to happen. So you authorize those conditions. And of course, as long as there is guarantees, that is one of the problems of these kind of therapies, and that's why we need the application of the principle of precaution and risk or experimentations with risks are acceptable within an order. What should we do? Well, accept or adopt the guarantees that are reasonably top limit before authorizing techniques. If then something happens, there will be responsibilities if things had not been done very well. And then if there has been another level of violation of norms, well, something else will be done. But you have to establish controls, and then if those controls have not been supervised, then well, responsible people will have to pay for that. Analysis with rigor before authorizing any stage. That's what I can think of. Yes, better to have fear instead of being hit. Yes, but you cannot paralyze yourself either, no? Because then there will not be advancement.